A1 is not present in court.
The former president for Forum for Democratic Change, retired Colonel Dr. Besigye, was not in court, although his co-accused Haji Obedi Lutale and Captain Ola Oyadenish were present in court. In the letter from the prison authorities, indicated that the accused, Dr. Besigye, is still undergoing treatment at Mulago National Referral Hospital as of last week, following his collapse in court. Although the letter was received from prison, the state brief lawyers asked court not to proceed with a trial in the absence of the accused, Dr. Besigye.
Prison that indicates that everyone is in Mulago Hospital. However, the requirements of a fair trial require that all accused persons ought to be in court for proceedings to go on. And it will be important for everyone to be present for these court proceedings to proceed. My Lord, prisons has indicated that it's admitted, but I think what is important for guidance of court would be for the medical personnel to be able to declare or to state the medical condition of the accused A1, particularly his suitability or fitness to stand trial or to start court process. I therefore pray that this honorable court be pleased to order the medical personnel to avail court with a report about the A1's condition. To stand trial so that we'll be guided how to proceed with this matter. Because his attendance at court is his constitutional right that cannot be dispensed with. So pray, my Lord.
My Lord, for the record, Thomas Jatiko, Assistant DPP. My Lord, we respectfully have listened to the two accused persons, and starting from the very third accused person, we agree. In fact, we have no choice, but he has given his wishes as to the lawyers on state brief, working with his two lawyers, Simon Subuga and Hanifa Namakula. And we are ready to proceed. My Lord, as for the submission of A2, in fact, the prosecution did agree with him that the presence of an accused person is very vital to proceedings in a court such as the one we are in. We fully agree with him. And in fact, it was our submission that this guarantee is protected under the Constitution, but it is not absolute. My Lord, there are provisions that this Constitution provides for, as well as other subsidiary laws, my Lord. We saw one of the accused persons raising his hand. Thought maybe would respond once. My Lord, we have had submission from the State Brief Council about the need to have medical personnel furnish court with the health status of A1 in order to guide this honorable court. My Lord, we are not yet privy of the contents of the letter from the prisons, so we do not know whether that letter contains information about this status, because the officer in court here from prisons has just told this court that A1 is in Mulago Hospital and a letter has been forwarded. And my Lord, be that as it may, we also, the last time we were in court, my Lord, the last time we were in court, we also prayed that we will proceed to respond to the status of the accused person. We intimated that we had an application to make, and my Lord, this proceeds from the constitutional guarantees that the defense has raised, that the presence of the accused must be guaranteed. My Lord, this is in fact very true, that the presence of an accused person at his trial shall always be protected. However, my Lord, this guarantee is not absolute, as the Constitution itself.
I think it is not proper to start submitting with that.
Much obliged, my Lord. This constitutional guarantee is not absolute, my Lord.
During the same court session, the accused, the Haji Obedi Lutale, raised concern of legal representation, alleging his lead lawyers, Elias Lukwago, was arrested and Martha Karua deported.
Let me hear from A2.
Thank you, my Lord. I'm Haji Obedi Lutale, A2 in this matter. My Lord, I want to make my position clear to this court this morning. When we are giving instructions to our lawyers, we gave joint instruction to our legal team that has been representing us. But as of now, our lead counsel, who was Counsel Martha Karua, was deported and denied entry back into the country. The second in command to Martha, Counsel Elias Lukwago, was abducted, tortured, and now in prison. The remaining lawyers are intimidated, threatened, and are now scattered. The last information I heard about Kiza has already run out of the country because of the intimidation. So, on the issue of our representation this matter, we have our application 248, which I think will solve our representation in this matter. The state-appointed lawyers here don't have our instructions or my instructions. So, my Lord, my prayer is to have my or our preferred lawyers so that we get a free and fair trial. Thank you. And I'm surprised with Mr. Jetty, the press shooter. Your Lord, have you told him that you got a letter from prisons telling him that the A1 is sick? I don't know what's the rush of the press shooter saying that we should proceed. And I had Madam Counsel here telling her that it's his constitutional right to be around when his case is being heard. But I don't know what's the rush for the prosecution to go ahead without A1, who he knows that he was by yesterday in the ICU in Bravo Hospital.
Yes, my Lord. Very good morning. I'm Captain Dennis for your order, actually in this case. I would like to report to this court that this morning I was with my counsel Simon Subuga within this court. But because he had some other commitment in another court, he had gone but said he will come back. So I would like to reiterate my earlier communication to this court that I gave my instruction to the lawyers on state brief to work together with my other two lawyers, that is Counsel Simon Subuga and Counsel Anifa Namakula. I would like this position to be on court record. Thank you, Madam.
Judge Emmanuel Baguma in his ruling ordered the Commissioner General of Prisons to get in touch with Mulago National Referral Hospital and later furnish court with a report whether Dr. Kizza Besigye is fit to stand trial.
Should get in touch with the Mulago doctors to get a report, write this one as a report. If A1 is fit to stand the trial. 2. The medical report from Mulago through the prisons will guide this court that indeed A1 who has been admitted is fit to stand trial. So this honorable court therefore is directing the prison officers to get that report specifically in respect of whether or not the accused A1 can stand trial. Lastly, if that report is available to this honorable court, then at the moment I'm giving this case 2 weeks adjournment. If we get that report, we shall proceed with hearing on 18th of this month and so on.
Much obeyed, my Lord.
There's no money. But don't fight.
Court will resume on 18th August 2026 for further hearing with an American investigator and Wilson Orlando. In another development, last week the International War Crimes Division High Court, before Justice Susan Okalanye, convicted Jamal Kiyemba, the former Guantanamo Bay detainee, with the offense of soliciting support for a terrorist organization, Allied Democratic Forces, ADF. Jamal Kiyemba, who has been on remand throughout the whole trial, he has been sentenced to 6 years imprisonment.
Stated that the convict was a first-time offender. He has been detained on the trial remand since 12 May 2022, amounting to 4 years, 2 months, and 19 days. In aggravation, State Counsel argued that the offense is of significant gravity because it endangers national security, public safety, and public order. The ADF is identified as a terrorist organization whose actions have caused loss of life, abductions, property, destruction, displacement of civilians, and widespread fear within Uganda. Counsel contended that terrorist organizations rely on external support to sustain their operations, and that soliciting such support facilitates acts of terrorism. She said that the offense was further aggravated by the fact that the solicitation took place at the old taxi park in Kampala, a public location frequently visited by numerous individuals from all over the country. Additionally, she referred to the penalty outlined in Section 12 of the Anti-Terrorism Act, which provides for a fine of 500 currency points and imprisonment for a maximum of 10 years. Counsel further argued that the sentence should protect the public and deter both the current offender and potential offenders. Considering the threat terrorism poses to national security and safety, she stated that a non-custodial sentence is unsuitable and recommended a custodial term of at least 7 years. In mitigation, Mr. Kabeda submitted that the convict is a 47-year-old first offender, a family man, a father of 7 children, and that his wife, aged 36, is a nursery school teacher at Remo Elementary School, Uboa, earning $600,000 per month. The children are aged between 5 and 19 years. Counsel submitted that before his arrest, the convict was the sole breadwinner and supporter of his family. He was also a cleric at Masjid Taqwa, and prior to his arrest was a responsible citizen. Counsel submitted that the convict had expressed remorse for his conduct and had been reformed by the lengthy period that he had stayed in custody. Counsel urged the court to consider the convict's history of previous incarceration. He noted that in 2013, the convict was arrested on similar charges, spent 6 months at Luzira prison before released on mandatory bail. The following year, in 2014, he was rearrested and remanded for 7 months before being granted mandatory bail. In 2015, he was arrested once more. He spent 4 years and 7 months in custody until the charges were withdrawn via non-prosecution, leading to his release in November 2016. Counsel also highlighted that on another occasion, earlier on, the convict had spent over 4 years in custody at Guantanamo Bay without being tried or convicted, and later released or received a certificate of clearance. With regard to the current case, counsel submitted that the convict was detained on 29 January 2022, remained in custody for 5 months before being arraigned. He urged the court to take into account the total duration of custody when determining the appropriate sentence. Counsel contended that there was no evidence of recruitment, financing, or violence in connection with soliciting support for the ADF. The incident appears to be an isolated occurrence. with no indication of ongoing solicitation. He also urged the court to release the convicts, to recognize the convict's bipolar disorder as a mitigating factor, notwithstanding the court's prior determination regarding diminished responsibility. Counsel submitted that deterrence and protection of society should be achieved without imprisonment. He therefore prayed that the period already spent on remand be considered sufficient punishment, or alternatively, that the court impose a fine. He proposed a fine of 20 currency points and suggested rehabilitative measures, including counseling, de-radicalization, and community service. In his allocutors, Mr. Kiyemba apologized for his conduct and expressed remorse. He referenced his bipolar disorder and clarified that although he comprehended his behavior, he was unable to control himself during a manic episode. He informed the court that he had received medical care while in custody and had not been admitted for further treatment. He requested a sentence characterized by empathy and leniency. In determining the sentence for the convict, I am guided primarily by Article 23, Clause 8 of the Constitution of the Republic of Uganda, the Anti-Terrorism Act, Cap 120, and the Constitution sentencing guidelines for courts of judicature, which actually do not, the latter guidelines do not give any specific range of terrorism cases. The convict was found guilty of soliciting and encouraging support for a terrorist organization. The section under which he was convicted, Section 12(1)(b), stipulates a maximum fine of 500 currency points and a maximum imprisonment sentence of 10 years, or both. Consequently, the court possesses discretion within the statutory boundaries to impose an appropriate sentence, considering the specific circumstances of both the offender and the offense. The offense is clearly grave. Soliciting support for a terrorist group can enable their activities posing risks to national security, public safety, and order. The fact that this solicitation took place in the old taxi park, a public area, heightens its seriousness. Consequently, the sentence that this court will mete out should emphasize deterrence and also safeguard the public. The sentence must also be commensurate with the specific details of the offense. In this case, there was no evidence that the solicitation led to recruitment of someone else, or providing financial material support to the ADF, or involved any violence. Additionally, no evidence indicated prior or an ongoing pattern of solicitation by the convict. The conduct also was confined to a single incident for which the individual was convicted. Although these factors do not justify the offense, they are relevant in assessing its seriousness as sentencing. I have also taken into account the convict's circumstances. He's a 47-year-old person, Ugandan, who is a first-time offender. He's married with 7 children aged between 5 and 19. Previously, he supported his family and worked as a cleaner. His apology is also a very important mitigating factor. I've also considered his bipolar disorder, not to challenge my own previous finding on his responsibility, but as part of his rehabilitation context. A key factor is the amount of time the convict has already spent in custody since 29th January 2022, up to the date of his conviction. I know that I have been asked to consider the time he spent in illegal detention, although no authority was provided to guide me on that. But the court will generally consider the time that he has spent on detention from the time he was remanded. I have carefully reviewed the convict's history of incarceration. which shows a pattern of prolonged and repeated detention without trial and conviction. A big indictment to the state on how cases are sanctioned and prosecuted. For one person to be charged, arrested, detained beyond the constitutional remand period, and released without charge, and arrested again the following year, and so on and so on. Smacks of persecution. I will not regurgitate what I have already said regarding his imprisonment in 2013, 2015, 2019. Additionally, I've taken into account, as I've already said, I've also considered as a mitigating factor the 4 years he spent in Guantanamo Bay without trial. I do not treat those previous arrests or withdrawn charges as evidence of offending or as aggravating factors in sentencing. Instead, their significance lies in highlighting the extraordinary lengthy periods of incarceration the convict has endured, which are pertinent to his, to my understanding of his personal circumstances and to the broader context of this case. In their submissions, State Counsel argued that I imposed 7 years. In contrast, the defense submitted that I consider the period that has already been spent on remand as adequate punishment, and that alternatively, I could impose a fine of 20 currency points. I've weighed these submissions in reaching my decision. Having considered the gravity of the offense along with the necessity for deterrence and societal protection, balanced against mitigating factors, such as the isolated nature of the conduct, the lack of evidence of recruitment, financing, and the defendant's accused persons or convict's personal and family circumstances, his remorsefulness, his mental illness, and extended period in custody. I'm convinced that a lengthy custodial sentence from this point onwards is not warranted. In my view, the time spent on remand, together with the sentence that I'm imposing shortly, should be balanced against the gravity of the offense. I sentenced the convict to 6 years imprisonment from the date of conviction, which is a fair proportion of the maximum sentence of 10 years provided by law. The time already spent on remand shall be deducted from this sentence. The period of remand, the remand period of 4 years, 2 months, and 19 days shall be credited towards the 6-year sentence that is imposed. And that leaves me with 1 year, 9 months, and 11 days. I have a problem of mathematics. Fail. I hope I'm correct. The prison authorities will do the necessary calculation if I'm wrong. But that's what I think from my calculation right now. That 1 year, 9 months, and 11 days is the period that the convict will serve starting from today. The convict is informed that you have a right of appeal against the conviction and against the sentence to the Court of Appeal within 14 days from this date. Before concluding this matter, I note that counsel for the defense alerted the court that the Uganda Prison Service held 2 detention warrants for the convict, one associated with CRA 530/2022 and the other with CRA 22/2022. This suggests that the convict was subject to 2 separate cases before this division. Counsel representing the state, Ms. Okwi, confirmed that this discrepancy arose from an administrative error at the Chief Magistrate's Court, where the case was erroneously assigned 2 distinct criminal case numbers. The error was subsequently rectified during committal proceedings on 15th December 2022, when CR 22 of 2022 was cancelled and replaced with CRA 530 of 2022. Consequently, accordingly, there is only one case currently before this division concerning this conflict, originating from Buganda Road Chief Magistrate's Court under CRA 530 of 2020. The Uganda Prison Service is directed to take note of this clarification. I so order.
In this case, Jamal Kiyemba was found around Old Kampala shouting at the top of his voice, "Long live ADF, ADF webewo." If the people don't subscribe to ADF, and if the government does not dialogue with ADF, there would be bloodshed in the city. Court, however, acquitted Jamal Kiyemba with offences of rendering support to a terrorist organization and belonging or professing to belong to a terrorist organization, ADF. It should be remembered that Jamal Kiyemba was once arrested in Pakistan in 2000, together with a US operative and suspected Al-Qaeda terrorists, while trying to enter Afghanistan.